A major legal battle has reached a critical turning point, with a federal court in Philadelphia delivering a nationwide ruling that could shake the foundations of religious freedom protections. At the heart of this case is a long-standing clash between two states and a Catholic order of nuns who have dedicated their lives to serving the elderly poor. But here's where it gets controversial. The court has now ruled against a Trump-era policy that shielded the Little Sisters of the Poor from being forced to cover abortion-inducing drugs and contraceptives in their health plans. This decision reignites a legal firestorm that has spanned over a decade, raising urgent questions about the balance between state mandates and religious liberty. And this is the part most people miss. The Supreme Court had already stepped in twice to protect the nuns. Yet Pennsylvania and New Jersey continue their relentless push to strip those safeguards away. What does this mean for the future of faith-based organizations navigating complex healthcare regulations? Let's break it down. The story begins in 2008 when the Affordable Care Act, ACA, mandated that employers include contraceptive coverage in their health insurance plans. While the rule initially offered exemptions for grandfathered plans, it left religious groups like the Little Sisters of the Poor, Catholic nuns who have cared for the elderly for nearly 2 centuries, without a clear path to avoid violating their beliefs. By 2017, the Trump administration introduced a rule to protect such groups, but Pennsylvania and New Jersey immediately challenged it, arguing that states should have the authority to override federal religious exemptions. The Supreme Court, in a landmark 2020 decision, sided with the nuns, reaffirming their right to opt out of the mandate. Yet the states refused to back down, and now a federal district court has thrown a new wrench into the mix by invalidating the Trump-era rule on a national scale. Mark Rienzi, president of Beckett and lead attorney for the Little Sisters, calls this ruling a reckless overreach by the states. It's not just about the nuns, he argues. This is about whether the government can force religious groups to violate their conscience. The court ignored glaring constitutional questions and skipped even a basic hearing after 5 years of delays. How absurd is it that we might need yet another Supreme Court showdown over the same issue? Rienzi's frustration is palpable, but the Little Sisters remain resolute. Mother Lorraine Marie McGuire, a nun from the order, emphasizes their mission. We serve the elderly poor because we believe it's God's call. We won't let political battles stop us from doing what we were meant to do. The stakes here are monumental. On one side, the states argue that public health and access to reproductive care should take precedence over religious objections. On the other, the nuns and their supporters claim that forcing them to fund services they morally oppose violates the First Amendment. Where do you stand? Should religious exemptions be absolute, or do states have a duty to ensure equitable healthcare access for all? Share your thoughts in the comments. This is a debate that's far from over. In the meantime, the Little Sisters have announced plans to appeal the ruling to the Third Circuit Court of Appeals, setting the stage for yet another chapter in this high-stakes legal saga. For those who want to dive deeper, contact Ryan Colby at Beckett for expert insights or to arrange an interview. The fight for religious liberty and the future of faith-based healthcare has never been more urgent.